testing hot for pot is no longer a thought. This presentation will be brought to you by Catherine Russell, Carly Franklin, and myself, Cassandra Allen. The purpose of this research is to explore published articles pertaining to the state of Nevada Assembly Bill number 132, how employers and employees will be affected, and the conflict pertaining to the bill that goes into effect next year. Online secondary data research was conducted to better understand how Nevada's Assembly Bill 132 will affect Nevada employers and employees. Multiple cases were reviewed to show how Nevada courts, as well as other state courts, have taken steps to protect employees from unlawful termination or refusal to employ based on the presence of marijuana in a drug test, or if the employee holds a medical marijuana card. The research also includes details such as what states have legalized medical marijuana use, going more in depth with Nevada to show the state's legalization timeline. A little bit about pot and where it's okay and not. Marijuana is still illegal under federal law. Marijuana is legal for medical and recreational use in 33 states and the District of Columbia. Take a few minutes to review this map. Maybe you're in one of the states that has legalized recreational marijuana use. The long road. Nevada's legalization timeline. Now let me take you back. 1929. Those caught with cannabis faced a misdemeanor and could be sent to a medical hospital at a judge's discretion. And let me move on to 2000. The Nevada Medical Marijuana Act was initiated. Now, blast to the future. 2015, the first medical marijuana establishment began to open. And in 2017, Question 2 took effect and legal recreation use of marijuana began. What is the law? I'm glad you asked. Welcome to Nevada. Assembly Bill 132 relates to employment, prohibiting the denial of employment because of the presence of marijuana in a screening test taken by a prospective employee with certain exceptions. It also authorized an employee to rebut the results of a screening test only under certain circumstances and providing other matters properly relating to the matter. Who signed this bill? Wouldn't you want to know? On June 5th, 2019, Governor Steve Sisolak signed Assembly Bill 132, which makes it unlawful for any Nevada employer to fail or refuse to hire a prospective employee because a drug test revealed the presence of cannabis. There are some exceptions. This will go into effect January 1st, 2020. What is this law exactly? Well, let me explain this a little more to you. Nevada is the first state to make it illegal to discriminate against recreational marijuana users. Instead of leaving it up to an employer to determine if they want a drug free workplace, they have to treat marijuana users as equal as non users, with some exceptions. Nevada employers now have to review and revise their pre employment drug testing policies before the new law takes effect. And here are some examples to the exception of AB 132 if prospective employees are applying for these positions below: firefighters, emergency medical technician, work that requires the employee to operate a motor vehicle where federal and state law mandates that the employee must submit a drug screening test. For example, truck drivers, jobs that could adversely affect the safety of others. Exceptions are allowed to fail the first pre employment drug test and retry the test after 30 days at their own expense. To sum it up just a little, that means you can't smoke any marijuana to have these jobs. These are a little bit of Nevada employers' policy changes that were suggested. Determine which jobs could adversely affect the safety of others. Update all the job descriptions. If testing for other drugs, make sure the test center does not flag marijuana users. Remind employees that being under the influence while on the job is still a violation that can result in termination. Switch to saliva or blood test with suspected impairment on the job. Drug Free Workplace Act. The Drug Free Workplace Act of 1988 is still an act of the United States which requires some federal contractors and all federal grantees to agree that they will provide drug-free workplaces as a precondition of receiving a contract or a grant from a federal agent. Marijuana is still considered a controlled substance due to it being illegal under federal law. AB 132 does not apply to positions funded by a federal grant, although many federal contractors and all federal grantees are still required to comply with Drug Free Workplace Act. Is there a conflict for workplace drug testing? In April 2019, testing lab Quest Diagnostic reported that marijuana was the most frequent detective drug in the workplace mandated urine screening. Only reason the employer had to stood by their use it and lose it line with medical marijuana use is because of the difficulty of determining when employees have last consumed the drug. In Arizona, the court found that employment decisions like the use it lose it could violate anti-discrimination provisions in state medical marijuana statutes. Downsizing of drug testing? Hmm. With nearly 1 million more jobs opening than unemployment people in the US, employers are beginning to find they're losing out on good employees by requiring drug tests. Many workers do not want to surrender their bodily fluid or medical history, who would, to their employers, or consider drug testing a sign that management doesn't even trust them. One of the first cases that caught our attention was Callahan versus Darlington Fabric Corporation. In June 2014, plaintiffs interviewed for an internship at Darlington Fabrics. At the interview, plaintiff signed Darlington Fitness for duty statement, acknowledging she would have to take a drug test prior to employment. During the interview, the plaintiff disclosed that she held a medical marijuana card. In July of 2014, Darlington held a meeting with the plaintiff. The plaintiff was asked if she was currently using medical marijuana, to which the plaintiff said yes. The plaintiff also disclosed that she would test positive for marijuana on her drug test. The plaintiff was then informed that she would not be able to be hired due to testing positive for marijuana. Then the plaintiff filed a three-court complaint on November 12, 2014. The plaintiff was covered under the Hawkins-Slater Act, which was an act passed to protect employees from being hired or wrongfully terminated due to holding a medical marijuana card. The court ultimately ruled in the plaintiff's favor, granting the plaintiff's motion for summary judgment on counts 1 and 3. Here's another case that might catch your attention. Whitmire versus Walmart Store Incorporated. An Arizona woman discriminated against an employee when it fired the employee due to her positive drug testing containing marijuana. Plaintiff held an Arizona medical marijuana card. She injured her wrist on the job, filed an incident report, didn't seek medical attention until 2 days later. Post-accident drug test was positive for marijuana. The plaintiff was suspended, then fired. Whitmire filed suit, alleging she was wrongfully terminated and discriminated against violation of various state laws. She sued under the Arizona Civil Rights Act, the Arizona Employment Protection Act, and the Arizona Workmen's Compensation Statutes. Walmart's affirmative defense were they fired her with the belief that she was impaired by marijuana at work due to the failed drug test. Walmart was unable to prove that the plaintiff's positive drug screen gave Walmart a good faith base to believe the plaintiff was impaired on the day in question. The court agreed with the plaintiff and ruled that Walmart had discriminated against her in violation of the AMMA by suspending and then terminating her solely based on her positive drug screen. Last but not least, Coates versus Dish Network LLC. Brandon Coates, a former Dish Network customer service representative, was discharged due to a state licensed use of medical marijuana during non working hours. Coates has been confined to a wheelchair since he was a teenager. On May 2010, Coates tested positive for THC. On June 7, 2010, Coates was terminated for violating the company's drug policy. Brandon Coates filed a wrongful termination case against Dish under 2434 402.5, which prohibits employers from discharging an employee based off engagement in lawful activities off the premise of the employer during non-working hours. Labor laws jurisdiction are shared between both state and federal. Because marijuana is a Schedule I drug, it is still unlawful federally. Mr. Coates argued that it is lawful under the Controlled Substance Act in Colorado. Dish argued it was a proper termination under the federal law, which Colorado Supreme Court ruled in the favor of Dish Network. It was a legalized controlled substance in Colorado, but federally it is still an unlawful act. If Colorado Supreme Court rewrites 2434 402.5 to define lawful activities to apply to state and federal law, Mr. Coates would have won this case in that matter. Does marijuana have a future? AB 132 goes in effect in January 2020. This means that in the states of Nevada, not only is there a future for marijuana, but also a future where employees who choose to use marijuana can be protected from discrimination. Businesses should ensure they have properly amended and clearly defined any policies regarding the use of marijuana and the consequences for employees under the effects of marijuana in the workplace. Clear guidelines are needed to explain to employees that they are required to be fit for duty. Society can limit legal liability by staying informed and educated on any rules regarding the use of marijuana, specifically relating to the workplace. To sum it all up, Assembly Bill 132 makes it unlawful for any Nevada employer to fail or refuse to hire a prospective employee because a drug test reveals presence of cannabis. Nevada stands out from other states because they are the first to protect employees who are recreational users of marijuana instead of only employees who hold medical marijuana cards. Employers affected by Bill 132 will have to adjust hiring, firing, and drug screening process to protect themselves from any potential issue that may arise. With the use of marijuana progressively becoming more accepted, it is up to the employees, employers, and society as a whole to be responsible when making any decision regarding the subject. And again, that's why testing hot for pot is no longer a thought.